Good afternoon. This is Scott Reisch, and we are here for another edition of Voir Dire, Legal Talk Edition. Today, we want to talk about, once again, the Chris Watts case currently pending in Weld County, Colorado. And those who are not familiar with this matter, we've been following it. It's the case of Christopher Watts, who is alleged to have killed his wife, Shanann, who was pregnant, and then his two small children. The case is currently pending up in Weld County, as I mentioned, and there's been some activity in the case. And haven't heard about this on the news or anything like that, but frankly, I just don't think they're following it that closely, and I don't think they really understand what some of this information may mean, and that's why I'm here to hopefully try and give some analysis to that, simply beyond the news clip that you're going to hear on the evening news. And what I want to talk about is that late last week, the defense for Mr. Watts filed a motion, and it's a motion titled Mr. Watts Motion for Leave to File a Pleading Under Seal pursuant to Administrative Order 2016-4 and further request to hold an ex-parte hearing on the issue. So, first of all, anything that gets filed in a criminal matter is going to be a matter of public record. And if the defense were to file this, obviously we would all have a copy of it, just like we are able to obtain a copy of what I'm holding before me. And so they're asking that this be filed under seal, and only the people that would have access to it would be basically the court, his staff, and the defense attorneys. The significance of that is that obviously they being Mr. Watts' attorneys, don't want the prosecution to know about it. Additionally, they want an ex parte hearing. An ex parte hearing would be only the defense would be available at the hearing and not the prosecution. And obviously that is going to take something of great significance, or usually involves some sort of issue regarding attorney-client communications or something along those lines. And so the reason why I think this motion is interesting, I'm curious to see what it holds, is that basically they state in their motion that Mr. Watts is concerned that the court may order the pleading be unsealed, and if it does, believe the information in the filing is protected by federal law. Specifically, they're referring to the HIPAA laws. And so they're worried about disclosure. And I pulled the HIPAA law that is applicable here under 42 U.S. Code Section 1320D-6, which is wrongful disclosure of individually identifiable health information. And it specifically states it's an offense for a person who knowingly and in violation of this part uses or causes to be used a unique health identifier, obtains individually identifiable health information relating to an individual, or discloses individually identifiable health information to another person. And then it says that that person shall be punished in subsection B of this section. For the purpose of the previous sentence, a person, including an employee or another individual, shall be considered to have obtained or disclosed individually identifiable health information in violation of this part if this information is maintained by a covered entity, as defined in the HIPAA privacy regulations. So we're talking about HIPAA information here. And obviously the defense attorneys are concerned that they have something and they don't want to disclose it because it appears that they could be fined up to 1 year in jail or a $50,000 fine. So then the information then becomes, what does the defense possibly have? And the reason why that's significant here is the defense has filed a couple of cases. They've cited a couple of cases in support of their proposition for this ex parte holding, and as basically deciding what they should do with this information. And they cited the case of People v. Cisneros at 55 P. 3rd, 797, and that's a Colorado Supreme Court. And it holds in that particular case, the court ruled that the government in that particular case had called a witness in a case. It was a sexual assault case, and this therapy helped refresh the person's recollection and the therapist testified as to what was or the victim testified as to what they did. They talked about in the psychologist's meeting, and the court determined that that was not a basis to waive attorney-client privilege, which I have a real problem with this. I've litigated this case recently. Very similar type situations. Somebody comes in, they have no memory of something. They meet with the psychologist, they go through some therapy, and next thing you know, everything just happens to come back to them, or it comes in bits and pieces. And then ultimately the question is, who put this in their mind? How did they remember it? Suggestibility, did it come to me in a dream? So I've got a real problem with that, but it helps give some indication of what they are holding, what the defense is holding, and they're not sure what the hell to do with it. And the other case that they cite is WESP, W-E-S-P versus Everson. And in that particular case, Miss Wesp was the victim of a sexual assault. Her stepfather had sexually assaulted her, or was accused of it, and apparently he committed suicide. And basically the father's estate was maintained the same attorney to handle the estate and wrap things up and handle the claims against the stepfather. And the issue there was basically revealing privileged communications that were obtained during these conversations. Apparently the father, the mother, and some other people were present during some conversations, and the question then becomes, was the attorney-client privilege waived? And when does this attorney-client privilege continue? And obviously understand the attorney-client privilege is one of the privileges that is sacrosanct in the legal system. You cannot go violating the attorney-client privilege unless you basically have a court order or your client has done something that waives attorney-client privilege. Because attorneys in the legal system want people accused of crime or even engaging in non-criminal activity of business. It's your business lawyer or your tort lawyer. You want the client to be able to feel confident that what you tell them is the truth, so that you can get the best legal advice and representation that exists. Now, obviously, if somebody comes to me and they tell me, I've killed 10 people and here's the location of the bodies. Well, guess what? I can never tell anybody that information. And the only way I could be forced to reveal some sort of communication in that regard is if somebody were to come to me and say actively, here's my information that I'm going to go, commit a homicide and this is what I'm going to do. If I have a real belief that a true threat was going to take place and that someone's going to go do that right now, then I would have to do that. But if they come to me after the incident and they tell me all the terrible things that they have done, I cannot tell anyone that unless the client agrees. And so what I'm speculating, and there's some speculation, but based upon the cases that the defense has cited, they filed this motion, and then late Friday, the court granted an order, 22nd. It basically said, go ahead and file this information under seal, and the court said that he will then determine whether it needs to be suppressed or whether it should be made available for public viewing. And basically, the court says, I don't even know what you have, but out of an abundance of caution, I'm going to let you file it, and then we'll decide what we need to do. So I haven't seen anything about any hearings being set. The information should have been turned over to the court, although I didn't see any submission receipt in the filings either. But we'll be following that because I think the defense has something. I believe the defense has some type of medical record that belongs to either the children or Shanann that they either obtained through the course of their investigation or somebody gave to them. And then the question is, who gave it, under what circumstances, and is there a waiver? Because some of the cases that they cite to basically says that in fact, they cite to it, here's the Everson case. It says, noting that attorneys may not disclose attorney-client privileged information even after the privilege holder has died. So, once again, nobody really knows what this means. The court indicated they didn't know what it means. I'm not exactly sure what it means, but I think it's worthy of some type of discussion simply for the fact that the attorneys are seeking guidance from the court as to what they can do with this document. And it sounds like it's obviously protected under HIPAA. So it sounds like it possibly is medically related. There may be, I don't know if she was seeking, obviously medical care. We know that Shanann had lupus. The case also that they cited, in that particular case, there was a suicide note. And so they were fighting over, they wanted the note. So it's very curious to see what the defense has obtained and how they obtained it. If it was randomly mailed to them, or if they came across it, or if it was in files that the family came across when they were cleaning out the house. Who knows? But it's going to be interesting, ladies and gentlemen. So, thank you for watching. Thank you for listening. Please, if you like what you see, go ahead and subscribe. Hit the like button and hit that little bell, and you'll be notified of the next time that we post something. You can download the podcast at Voir Dire. It is on iTunes. It's on a bunch of other sites. You can also watch us on YouTube at scottreisch.com. And we appreciate it. And let us know what you think. Obviously, this Chris Watts case is taking an interesting turn. It's going to get really exciting here real soon because they're going to be setting a preliminary hearing. We're going to see what kind of documents, if any, we'll find out as to what was turned over to the court to view and decide whether they need to have a hearing on it, who possesses the privilege. That's exciting stuff. That's exciting legal stuff because it sucks when you have really great information as a defense attorney and you can't use it, or you know it's there, but you can't get to it. And so it's going to be good. It's going to be good. So if you like it, subscribe. If you want to leave a comment, let me know what you want to talk about on this Christopher Watts case, or if there's another case out there that is of great interest to you, please let me know. We can talk about it. Obviously, it seems like the world is just absolutely going crazy. We've got people mailing bombs. We have people shooting up synagogues, and it's absolutely crazy what's going on in the world. So we'll be talking about it. We'll be talking about some interesting cases, and I've got a real interesting case coming up here soon that I'd like to talk about. It was a case that's currently up on appeal, but I think it's just rather interesting, great issues, and I think it'll be intriguing to a lot of people. Maybe try to make that into some sort of a serial episode because I've got some great transcripts, and it's really an interesting story. So have a great day. Continue to watch. And we'll be following the Watts case and providing in-depth legal analysis because, frankly, no one else is doing it. Have a great day.